the story of Ms. Knott and Sedgwick's use of the appeal process. Now, I will tell you that in an ERISA case, you have to file an appeal if the claim has been denied. You have 180 days in which to appeal, and that is the trial of your case. There is no real trial like you see on TV. Ultimately, if parties don't resolve the case, it's decided on what's called a motion for summary judgment. A bunch of pleadings we lawyers write, and the judge ultimately decides whether the person is entitled to their benefits. Now, in writing the appeal, you have to understand the terms of the disability policy or the plan. Among those are, what's the definition of disability? What's the definition of occupation? What's the nature of the proof? And by the way, what's the vocational evidence and medical evidence that they're relying on in creating this denial or termination? And if you don't understand any of this, and you certainly don't have a copy of the claims file, it's going to be really hard to write a winning appeal letter. So let me tell you the story of Ms. Knott and how the claim was doomed. She worked for Allegiant Technologies, and she was paid 52 weeks of own occupation benefits. What will happen normally is that after 1 or 2 years, benefits will change from an inability to do your own occupation to an inability to do any occupation. And when she filed the lawsuit, she subsequently tried to introduce new evidence that was outside of the claims file, including a letter from her treating provider disputing that he had had a call with Sedgwick's providers as alleged in the final denial letter. Now, the court said, no way, I'm not letting that in. And they did that on the basis that under the arbitrary and capricious standard of review, the court can only look at what was in the administrative record, the claims file, through the appeal process. Now, in this particular instance, this alleged conversation was first mentioned in the final denial letter, but I quite frankly think that was problematic. But hopefully, that letter could or should have been submitted before the time deadlines. Because remember, have 180 days in which to file an appeal. They have 245 days, 90 days in which to respond. And certainly under ERISA regulations, you do have the right to respond to that type of evidence. But in this instance, the court said, no, there's been a review of the file by the liar for hire doctor. They reviewed the peer review reports. They reviewed the vocational report. They considered evidence. And the fact that there was this little telephone conference mentioned between the treating provider and the peer review doctor is not arbitrary and capricious. It's just one of those factors in the myriad of evidence and analysis they did in arriving at the basis for the denial or the termination. Now, I think that analysis was absolutely wrong, but that's ultimately, of course, what the court did. You can see the games that are played by disability carriers and plans like Sedgwick. The first key is they're going to try to have an arbitrary and capricious standard of review. They're going to give the TPA, like Sedgwick, or the carrier or the plan administrator, the discretion to determine what the language in a policy or plan means. They're going to give them the authority to determine entitlement to benefit. They're going to play games with this transition period from short to long-term disability benefits so that they can argue that the policyholder or plan beneficiary is not entitled to the balance of their short-term disability benefits and is not entitled to long-term disability benefits. They're going to use the language of the policy or plan. If there is an objective evidence requirement, they are going to be looking at those medical records with a fine-tooth comb, looking for objective evidence that they can attack, or hanging their hat on the lack of objective evidence. And they're going to create a web, if you will, a tale of what are the reasons for this denial or termination of benefits. They're going to create a story. And you need to be able to create your own story that rebuts what's going on. You've got to argue that their activity is arbitrary and capricious, that they have misinterpreted the terms of the policy or plan, that the evidence that they have created or the reasons that they have created for the denial or termination are arbitrary and capricious by attacking the basis of the opinion, what information they may have had, what speculation their peer-reviewed doctors are making in denying the claim. So you want to argue the totality of their actions. There are 12 circuits, federal circuits in the United States, the 11th and the 1st to the 11th and the District of Columbia. Each of them have their own standard of review. And so part of the reason why you should have a lawyer is because the lawyer will understand what that standard of review is and what that particular circuit court is looking for to make a successful argument that the decision to deny or terminate your benefits were arbitrary and capricious. We've had a lesson today in Sedgwick claims handling, but also I think in the claims handling of disability plans and carriers. I hope that you have enjoyed this week's episode and you've learned something about the games that disability carriers or plans will play. If you've enjoyed this episode, please like our page, leave a review, share it with your family and friends, and of course, subscribe to this podcast. This way, you'll know when our next episode comes out and you can tune in. Thanks, and we look forward to talking with you next week for another insightful episode of Winning Isn't Easy.